Ready? Start. The defense plea that PW2 had received the injuries on the evening of June 23 and not in the morning of June, 24 gains credence from the fact that an incident between the two sides had admittedly taken place on the evening of June 23, 1995 full stop. In the face of this admitted position and the medical evidence, it is difficult to accept that the injuries found on the person of PW2 were received by him in the morning of June 24 full stop. From this, either of two inferences would logically follow. 1, PW2 was not present at the occurrence in which the deceased was killed in the morning full stop. The occurrence in which the deceased was killed did not take place in the morning of June 24 and he was not killed in the manner as suggested by the prosecution full stop. Both the inferences are equally damaging to the prosecution case full stop. In view of the facts and the circumstances, it would be highly unsafe to uphold and sustain the appellant conviction for the offense of murder, and the prudent and safe course would be to give him the benefit of doubt full stop. Accordingly, he is acquitted on the charges under section 302 and 324 IPC full stop. The next appeal is directed against the judgment of the Punjab and Haryana High Court in Criminal Appeals numbers 201 under bracket 3 of 1996, confirming the appellant's conviction under section 302 of the Penal Code and the sentence of life imprisonment awarded to him by the trial court for having committed the murder of Kamlesh full stop. In his statement before the police, he said that in the morning he along with his two younger brothers, Ram Kumar under bracket PW5 and Kamlesh under bracket the deceased was sitting on the chabutra of their bathak in village, Keshopur when Kamlesh proceeded for his house to bring the clothes for getting ready to go to Faridpur, where he was due to appear in the BA examination full stop. As he reached the Chaupal, where the lane turned, he was waylaid by the accused under bracket Karam and Rampal who were armed with knives full stop. As to the cause of the incident, he stated that shortly before the occurrence, his younger brother Suresh was elected as the village sarpanch full stop. He did not pay any heed to his demands full stop. This greatly annoyed them as they thought of themselves as the Chaudhry of the village full stop. This had led to an altercation and an exchange of hot words between the two sides on the previous evening, but the matter was then patched up by discussion full stop. He finally stated that the accused in league with one another had killed his brother Dinesh by giving him life and lathi blows full stop. After the occurrence, he brought Kamlesh to the civil hospital, Kanpur, where he was declared brought dead full stop. Dr. Pawan Kumar under bracket PW3, who was in the hospital on duty, sent information in that regard to the SHO, PS Keshopur, whereupon PW8 came to the hospital and took down the statement of the appellant full stop. The FIR was delivered at the residence of the area magistrate on the same day full stop. What is, however, of significance for our purpose is that the trial court disbelieved a substantial part of the prosecution story full stop. The trial court did not accept the prosecution case that accused were present at the place of occurrence and, accordingly, directed their acquittal full stop. As regards, the trial court pointed out that the three incised wounds on the person or the deceased that were attributed to him were, according to the medical evidence, post-mortem in nature, that is to say, those three injuries were inflicted after Mahesh was already dead, full stop. The medical evidence, thus, clearly eliminated the participation of Rakesh in the case, full stop. He too was, therefore, acquitted, full stop. The acquittal of the three accused brought down the number of the remaining accused for the shared common intention with the appellant, full stop. Apparently, that was one of the reasons for their conviction simply under section 323, full stop. Apart from the three accused whose presence at the place of occurrence was not accepted, the trial court also doubted the presence of two out of the three eyewitnesses, full stop. The trial court further held that even PW2, the only remaining eyewitness, had mixed up truth with falsehood, but his testimony was not liable to be discarded wholly since he himself received injury in the same occurrence, full stop. In regard to the injury, the trial court came to a truly amazing conclusion, full stop. The injury on the hand of Rakesh was certainly in existence and it was also proved by the medical evidence, full stop. The trial court resolved the contradiction by fastening the injury to Rakesh to, full stop. Stop.